people, this is Pops from Legal Reform. The key to legal reform is basically knowing the rules of professional conduct, code of judicial conduct, and simply remembering that they took an oath to do this. Every judge and every judge is taking an oath to defend the Constitution, basically your right to due process. Every lawyer is taking an oath to defend your right to due process. And that's what you're going to use against them. The oath they took, word for word, okay? So the easiest way is a lot of people want to take out them corrupt judges. Okay, so here we go. Complaint form, U.S. federal claims. We're going to go down here because this is Indiana or Illinois. Where's that in Indiana? How do I report a judge? What are 4 types of judicial misconduct? How can I file a case against a judge in Indiana? No, I don't. Okay. Small claims court. You must report. Yes, you must report judicial misconduct. Illinois State Bar. So if a lawyer knows a judge is violating the code of judicial conduct, he is legally obligated. He or she is legally obligated to report the judge. And reporting misconduct is mandatory in both the code of judicial conduct and the rules of professional conduct. Okay, so if this is, that's got to be Indiana. Okay, frequently complaint form, let's put in, no matter what state you're in, how to file, here it is. You just type in rules of professional conduct, code of judicial conduct, it will come up. Okay, how to file a complaint against a judge. Request a complaint form by contacting the board. That's the board of the Judicial Inquiry Board is what it's called in Illinois. Every state has a different name, so you have to look it up, basically like I'm doing, okay? A lot of people used to laugh at me because I said I talked to my computer to find out answers. They took me literally. I was speaking figuratively. Okay, you may also download a complaint form from the board's website. Okay, so here we go, Illinois.gov. All right. See, so all you really want is the complaint form. I'll tell you what to put in there. Claims filed, constitutional authority rules. You might want to look that up. But right now, we just want the complaint form. Okay. Download materials. That usually shows you complaint against the judge. Okay, check it out. Check it out. They give you the form too. And you can file it electronically, okay? Your name, address, city, state, daytime telephone, evening. You must provide the board with any changes of address information to receive correspondence after you've submitted your complaint. How did you hear about the Judicial Inquiry Board? Notice posted in the courthouse? No, they don't do that. Another state agency? Nah, they don't do that. Internet? Just put Pops. That's kind of my name, but it's basically what I do. Protect our peoples. I give a crap what color they are, what ethnicity, what religion, This is the law. Okay, Illinois Attorney Registration Disciplinary Commission, that's the ARDC, where you file complaints against attorneys. Well, see, if you go through the Judicial Inquiry Board, take down a judge, you're going to take down the attorneys. Okay? So here's the complaint form. Last name of judge, first and last name of judge, county, Supreme Court, Appellate Court, Circuit Court. Okay? And if this don't work, then there's the federal court. Statement of facts. When and where did this happen? The date, the time, the location. If your information is right out of a court case, please answer these questions. What is the name and number of the case? Okay. What kind of case was it? Domestic relations, criminal, law magistrate, probate, juvenile, small crimes, traffic, chancery, and others. I've helped a lot of people out in domestic relations, criminal. Some people I talked to them through probate, but I just gave them a copy of the Rules of Professional Conduct, Code of Judicial Conduct. Tried to explain it to them. I even help people in traffic court, small claims, and also eviction court. And all this applies to lawyers and judges, no matter what. Okay, so that's it. That's okay. If you're represented by an attorney in the matter of this conduct, judges, please identify the attorney. Okay, so you want to throw your attorney's name up there because your attorney sold you out. They all do. Okay, but we're going to have to go over the Code of Judicial Conduct. Okay, so let's go back, and I'll show you exactly how you start it. Okay. Okay, let's just go here. Illinois Code, JDI. Okay. So I'm in Illinois, so I'm going to use this. Whatever state you want, you just type in the name. If you're just in your state, just type in Code of Judicial Conduct, all right? Okay, the preamble. You're going to want to read the preamble, okay, and use that against them. Our legal system is based on the principle that an independent, fair, and competent judiciary will interpret and apply laws that govern us. Okay. Terminology, you want to use that. Okay, but I keep telling people, if you do this, I explain these are big guns. These are what you use to take a judge down. You're going to want to refer to Canon 1, Canon 2, Canon 3. But there's Canon 3. But we're going to start off with Canon 4. Nope, not Canon 4. You're going to use all this, but I just want to get to the... Did you know that a judge or judicial candidate shall refrain from inappropriate political activity, meaning the courts are apolitical. They cannot take a side when it comes to politics. I want to go over that with you on another video. Administrative order. Judges often don't do this. A judge should be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, and others whom the judge deals in an official capacity, and should require similar conducts of lawyers and staff, court officials, and others subject to the judge's discretion and control. A judge should accord every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to the law. A judge may make reasonable efforts consistent with the law court rules to facilitate the ability of self-represented litigants to be fairly heard. Judges don't do that. But you'd have to actually be in a court of law and forced to represent yourself to understand that they don't do that. Where is it? A judge should uphold integrity. Okay. Canon 2, a judge should respect and comply with the law and should conduct himself or herself at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. So you should remember that, all right, because they don't enforce the rules of professional conduct. That's their job, to enforce the rules of professional conduct. And these are the rules that apply in a court of law. We're going to go over that because that's all the ammunition you need to get at the judge. The judge should not allow family, social, or other relationships to influence the judge's judicial conduct or judgment. The judge should not lend the prestige of judicial office to advance the private interest of others. A judge should be faithful to the law, maintain professional competence. A judge should be unswayed by partisan interest, public clamor, or fear of criticism. Partisan interest, political. Okay, they can't do anything just because of political interest. A judge should maintain a decorum in the court proceeding before a judge. Okay, a judge shall accord every person. A judge shall not issue. Okay, a judge shall devote full time to his or her official judicial duties and should dispose promptly of the business of the court. You're familiar with the term of quick and speedy trial, 120 days. They don't enforce that. Okay, but we'll get to the rules of professional conduct where you can use this against your judge. If you want to take the judge down, when you take the judge down, your attorney, the opposing party, everybody goes down. It takes a domino effect. Okay, a judge having knowledge of a violation of these canons on the part of a judge or a violation of Rule 8.4 of the Rules of Professional Conduct on the part of a lawyer shall take immediate appropriate disciplinary measures. So 8.4 of the Rules of Professional Conduct is misconduct. It says misconduct. So misconduct, we'll get to that. But we're going to see the judge is supposed to report a lawyer if they don't follow the rules of professional conduct. So if they violate one rule, that violates Rule 8.4 of the Rules of Professional Conduct, which is misconduct. And the misconduct can be a lack of competence, expediting litigation, communication. So many ways lawyers break the rule, violate the rules of professional conduct or commit misconduct in a court of law. So you're going to use misconduct and then state the other rules afterwards. See, it says, judge having knowledge of the violation of these canons on part of a violation of Rule 8.4, okay? Okay, so reporting misconduct is mandatory, okay? Reporting misconduct is mandatory. So let's go here to the rules of professional conduct. You don't want the American model rule. You want your state rules. Okay. Okay, Illinois. I've been using Indiana, trying to explain to some people in Indiana, but so that's why that keeps coming up. Illinois is, see, we'll go there, just straight there. I already have that saved in my tabs. Okay. Now, I've had people sit in with me on conversations that they thought were casual conversations. Recently, I got a call from a predator creditor claiming I took out a loan over the internet. And I said, well, how did you, they gave me my information, my email address, my phone number, and where I used to live, okay? And so I said, well, I said, are you a lawyer? They said, no, we're a litigation team. I said, you're a litigation team? They said, yes. So then I brought up, where is it? Expediting litigation. Oh, these are Supreme Court rules. Here it is. So I asked them, is this what you're doing, expediting litigation? He says, excuse me, sir? See, people think this is a casual conversation that I have with lawyers. But actually, they laughed at me. I says, no, this is legal talk. So I said, this is what you call expediting litigation. They, excuse me, sir? I said, yes. Expediting litigation would show competence. It would be diligent. Okay, thus far, all we got is a lack of communication. So I said, in fairness to the opposing party, expediting litigation is necessary, okay, to show competence, diligence, and, the communication necessary to proceed in court. Thus far, all you have is somebody that stole my information off of the internet. You don't have anything proving that I got the money. I have access to my own bank account. I says, no money ever reached me. I mean, can you verify my signature? Say, I'm sorry, sir, we didn't mean to bother you, and we will write this off as a fraud. And they said it'll be they bought it off the internet from somebody that said that they sent me money. But see, people think that casual conversation, they would laugh at me in court. And the lawyers would walk away and leave us alone. And they say, what did you do? What did you say? I said, that is legal talk. I says, I was just showing that I was being competent, diligent, through communication, and determining whether these were meritorious claims and contentions. I was displaying candor toward the tribunal in fairness to the opposing party, impartiality and decorum of the tribunal. Okay, so I know what's inside these rules. they're the definitions. I know the definitions of these. I found this in a book in 1980. The revised edition was in 79. Then I looked for the Code of Judicial Conduct because it mentioned it in here, but I didn't know where to find it. This was before computers, so and these books nobody wanted to give up. Okay, so you can actually take down the 8.4 misconduct. Okay, let's go to misconduct. That's what the Code of Judicial Conduct was. Okay, it is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so through the acts of another. So your lawyer got the judge to violate the rules of professional conduct by not reporting misconduct. Okay, you can download this, as I say, and then highlight. Seriously, you got it. The only way you're going to get through this in court is if you take the copy of the Code of Judicial Conduct, the rules of professional conduct, and 4 copies, one for you to go over, one for the judge, one for your lawyer, and one for the other lawyer. And you're going to go over every issue you have with them, okay? And you're also going to want to take a copy of 3 definitions with you because they're going to play stupid. You're going to take a copy of the definition of rule of law. Simply put, nobody above the law, nobody below the law, equal justice, letter of the law. The letter of the law means what you see is what you get. Lawyers and judges will often say, well, this is not how we interpret this or interpret that. But letter of the law clearly specifies the definition is contained within itself. So you don't need anybody giving you or explaining you what it means to them. It says what it says. It is what it is. It's a contract. This is the oath they took. This is a contract they took, and they have to do this word for word. Okay, simple as that. Spirit of the law means the greater good. Everything has to be done for the greater good, in the interest of the public, to maintain the public trust. And that's in the rules, in the preamble of the rules of professional conduct. Okay. Commit a criminal act that reflects adversely on a lawyer's honesty, trustworthiness, or fitness as a lawyer. A criminal act is violating the rules of professional conduct. Misconduct is a criminal act. Engage in conduct involving dishonesty, fraud, deceit, and misrepresentation. Them not telling you any of this is engaging in conduct involving dishonesty, fraud, deceit, and misrepresentation. You're supposed to know this. They don't tell you. They're supposed to educate you on this. But that's in the preamble of the rules of professional conduct. We'll get to that. Engaging in conduct is prejudicial to the administration of justice. Them not telling you this is okay. So in every word, every sense of the word, the lawyers and judges are violating their oath. Okay. Knowingly assist the judge or judicial officer in conduct that is violation of applicable rules of the judicial conduct or other law. Nor shall a lawyer give or lend any value to a judge official. Listen, this is how lawyers and judges get rich, through professional procrastination. Participate in presenting, therefore, to present criminal or professional disciplinary charges to obtain advantage in a civil matter. Enter an agreement with a client, former client, limiting or purporting to limit the right of a former client to file, pursue a complaint before the Illinois Attorney Registration and Disciplinary Commission. So a lawyer can't try to talk you out of this. Okay. In which they will. In some states, in Illinois, they don't have a grievance. In some states, they do have it where you file a grievance before you file a complaint. But they use their grievance to convince you not to do this, file a complaint. Okay? So that alone is a violation of the law. Okay, so screw the grievance people. Don't do the grievance thing. They're going to tell you this is not how we interpret this, and this is how we do this, and this is how we do that. and this is how we work it. That's how they work it, but that's not how it's supposed to work. Okay, so don't do the grievance. That's just them conning you, telling you you're not going to get your way. But once you put this on paper, once you get this on the record, that's why, if you got a case, you can easily shut it down, end it by, doing this, okay? Okay, so that's misconduct, okay? So it tells you. So misconduct means they can't violate any of the rules. Okay, so let's start from the top. Competence. Okay. A lawyer shall provide competent representation to a client. Competent representation requires a legal skill, knowledge, thoroughness, and preparation reasonably necessary for representation. That doesn't happen. Because in order to be competent, a lawyer must be diligent. A lawyer shall act with reasonable diligence and promptness in representing a client. So, you read all this. This will give you a better outlook, okay? So in order to be competent, one must be diligent. One must communicate. Serious lack of communication. Always a serious lack of communication. Lawyer shall promptly inform the client any decision, circumstance with respect to which the client's informed consent. Informed consent is necessary before anything proceeds in a court of law. Okay, you don't know this, so how are you going to give informed consent if you didn't know the rules of professional conduct, the code of judicial conduct exists, and lawyers and judges are required to do this? This is the oath they took. Okay, they took an oath to do this. They have to do this word for word, to the letter. Judges are supposed to enforce this. They don't. Lawyers are supposed to do all this, and they don't. Okay, promptly reply with reasonable request for information by you. They don't give you shit. They talk a language you don't even understand. And that's a violation of rule of law. They're treating you like a lawyer, but yet you don't have the legal knowledge, the learned skills of a lawyer. You don't have the education they do. So they're sticking you in a master chess tournament and you suck at checkers. Okay, you're gonna lose. So you can demand that they keep it in layman's terms as to keep you informed. So that way you can have informed consent. Reasonable knowledge to make an informed consent is mandatory in the court of law, which is in the preamble. We haven't gotten to that yet. Consult with the client about any relevant limitations of a lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules of professional conduct law. The lawyer shall explain the matter to extent reasonably necessary to permit the client to make informed decisions regarding the representation. So you want to read this, communicating with the client. All right, I'm just trying to make this brief. Confidential information. They don't do that. Whatever you tell your lawyer, your lawyer will run and tell the judge. That's what got my ass left for dead, because the judge found me guilty, and I couldn't believe that. And the lawyer wasn't doing his job because I knew this. And when they took me back, I called him out on bullshit. And I said, when I get back out there, watch and see what he do. He says, what are you going to do? Just tell the judge to do her job. Report you for misconduct. And he looked at me with a scared look in his eyes. He said, reporting misconduct is mandatory in the rules of professional conduct and the code. And before I finished saying code of judicial conduct, he ran out of there. The judge is supposed to cite my lawyer for ineffective assistance of counsel, have him locked up, knocked out, beat up, just like they did to me. Okay, conflicts of interest. You might want to look that up. Duties to former clients. Clients with diminished capacity. Some people are dealing with that. Declining or terminating representation. They can't do that. There's a special, so, I had a kid in court, and his lawyer was declining or trying to terminate representation because the kid's like, hey, he's citing the rules of professional conduct. Judge, I just want him to do his job. And I told the kid, no, you don't ask. You don't go in there like Oliver Twist. Sir, can I please have some more? No, you go in there and demand it. When I go into a court, I storm in there like Godzilla struck through Tokyo. And it's because I know this. All right? So they can't. I can't. It was a public defender demanding to asking the judge if he could terminate representation because the kid was demanding he do his job, and the kid was literally quoting the rules of professional conduct. I have a transcript of that. I'll show it to you. Duties to a prospective client. Meritorious claims and contentions. Nothing can be meritorious. Okay. A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis of law, in fact, for doing so. It is not frivolous, which includes good faith argument for an extension, modification, or reversal of existing law. A lawyer for the defendant in a criminal proceeding or the respondent in a proceeding that could result in incarceration may nevertheless so defend the proceeding as to require that every element of the case be established. So every element, they can't just go in there and make up shit, come up there with Facebook memes, conspiracy theories and say, hey, no, that violates 3.1, meritorious claims and contentions. Expediting litigation. Okay, a lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the clients. So that leaves no room for continuances. When a lawyer walks in, he can't ask for a continuance because the opposing party didn't give him some paperwork. I mean, seriously, if I were a judge, the oath I took would require me to say, hey, some bitch, go across that room and get it from him now. Go get it for him. There's no need. Expediting litigation, you really got to get into that, okay? Because this is a rule, there's no reason for constant continuances because they don't have video cam, dash cam, personal body cam, hospital reports, police reports. All this is litigation, and they are required to expedite it. That's why I never understood why, people tend to it's withholding evidence. Candor towards a tribunal, that rarely happens. Candor towards the tribunal, a lawyer shall not knowingly make false statement or fact of law to a tribunal or fail to correct false statements, material fact that the lawyer previously made to a tribunal by a lawyer. Fail to disclose to the tribunal legal authority and controlling jurisdiction known to the lawyer. Offer evidence the lawyer knows to be false. The lawyer who represents the client in the adjudicated proceeding and knows that a person intends to engage or is engaging or has engaged in criminal or fraudulent conduct related to the proceedings. Okay. So you really, you really want to get into this. See, that's what makes me good because I know what's in here. Fairness to the opposing party and counsel. So they see these casual conversations aren't actually casual. I'm citing the law. The lawyer shall not unlawfully obstruct another person's access to evidence or unlawfully alter, destroy, or conceal a document, thus expediting litigation, a document or material having potential evidentiary value. The lawyer shall not consult or assist another person to do any such act. Falsify evidence, counsel or assist a witness to testify falsely or offer an indictment to the witness that prohibited by law. Knowingly disobey an obligation under the rules of a tribunal except for open refusal based on extortion that no valid obligation exists. Okay, so fairness to the opposing party, counsel, they violate that rule. Once a lawyer violates one rule, they're destined to violate multiple rules. impartiality and decorum of the tribunal. Okay, there's a good one. A lawyer shall not seek to influence a judge or a prospective juror or other official by means prohibited by law, communicate ex parte. Okay, so you want to get into that. Impartiality, and it just means what it says, impartiality and decorum of the tribunal. Okay? Special responsibilities of a prosecutor. For criminal cases, this is the only different rule for criminal cases. All right, but all those rules apply to every lawyer, no matter what side of the courtroom they're on. Defense, prosecution, whether it's civil court, criminal court, as you've seen in the Code of Judicial Conduct. Okay, refrain from prosecuting a charge that the prosecutor is not supported by probable cause. Which in a criminal court, the first thing you should have is a probable cause hearing. That's first and utmost. But lawyers charge you a whole lot extra for, and the public defenders refuse to have a probable cause hearing because that could end the case quick, fast, in a hurry. You see, I seen some video where some kid was telling off a cop. The cop got mad because he didn't like the kid mouthing off to him, so he arrested him. Listen, freedom of speech. Using your freedom of speech is not probable cause for arrest. That's nothing but legal harassment, which is explained if you go through all the rules. It'll explain to you that that's nothing but legal harassment. So not having a probable cause hearing is legal harassment. And that's by your own attorney. Make reasonable efforts to ensure the accused has been advised of rights, which they don't. You have the right to remain silent, but that is always infringed upon. Asking any questions is entrapment. They're trying to find probable cause for arrest. All right. So your rights are consistently, especially in a court of law, infringed upon unless you know them, use them, and flex them. Okay. So anytime you're out there on the streets, you have a right to be silent. It's in the Fifth Amendment as well as the 14th Amendment of the U.S. Constitution, the right to remain silent as to not incriminate yourself. And if you don't say that right away, they're not going to give it to you. They will beat what they call interrogation. There isn't supposed to be an interrogation if you have the right to remain silent. Okay, so flex your rights. Make timely disclosure to the defense of all evidence or information known that the prosecutor attempts to negate the guilt of the accused or mitigates the offenses in connection with something. Disclose to the defense tribunal all unprivileged or mitigating information known to the prosecutor, except when the prosecutor is relieved of responsibility by a protected order of the tribunal. Okay, so you really want to get into this. Okay, the one I want to use that will help in some cases I'm working on is if I can get some people to walk down to the courtroom. I have some exonerating evidence in a few cases, exculpatory evidence that should exonerate some people. All right, but the last time I went to the state's attorney's office and tried to do this in one of the cases I was involved in, I got chased out of the building. And like I said, I was already left dead once trying to get this on the record. So anytime they threaten my life or my freedom, with jail because, I want to get this on the record. Okay, when a prosecutor knows of new, credible, material evidence creating a reasonable likelihood that a convicted defendant not committed an offense of which the defendant was convicted, the prosecutor shall promptly disclose that evidence to the appropriate court or authority, and if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless a court authorizes delay and undertake further reasonable investigation or make reasonable evidence to cause an investigation to determine whether or not was convicted of offense that the defendant did not commit. When the prosecutor knows of convincing evidence establishing the defendant in the prosecutor's jurisdiction was convicted of offense the defendant does not commit, the prosecutor shall seek to remedy the conviction. The prosecutor's judgment may in good faith if the evidence does not rise to the standard stated in paragraphs subsequently determined to have erroneous does not constitute a violation of this rule. Okay. Now let's go over. Now this is a standard set back in 1935. Okay, the state's attorney's official capacity and the representative of all people, including the defendant. Most people don't realize that the state's attorney in his official capacity is the representative of all the people, including the defendant, and which is as much as his duty to safeguard the constitutional rights of the defendant as those of any other citizen. People versus Cohen. Okay, now this was in 1924. Okay, but they don't do that, so you might want to use that against them. In 1935, the United States Supreme Court decided the duty of a federal prosecutor in the following passage. The United States Attorney is a representative not of an ordinary party or controversy, but of a sovereignty whose obligation is governed impartiality and is compelling as it is obligation to govern at all, in which interest therefore in a criminal prosecution is not that it shall not win the case, but that justice shall be done. In a criminal prosecution is not that it shall win the case, but that justice shall be done. Okay? As such, he is a peculiar and very definite sense of servant of the law. All lawyers are servants of the law, which make them public servants. The twofold aim in which the guilt shall not escape or innocent suffer. Okay? The innocent shall not suffer. He may prosecute with earnestness and vigor indeed, he should do so, but while he may strike hard blows, he is not at liberty to strike foul ones. It is much as his duty to refrain from improper methods calculated to produce a wrongful conviction. It is to use of every litigant means to bring about a just one. Berger versus United States. Okay, that was in 1935. Okay, so that's the only special rule as prosecutor. That's the only one that stands out as far as criminal cases. But all these rules abide to every lawyer except for 3.8 in every court of law. Truthfulness and statements to others, they violate that. Okay. In the course of representing a client, a lawyer shall not only make false statement, material fact, or law to a third person, or fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client unless disclosure is prohibited by Rule 1.6, misrepresentation. Okay, it's misrepresentation in the law. Dealing with an unrepresented person. They do this, dealing on behalf of a client with a person who is not represented by a client. A lawyer shall not state or imply that the lawyer is disinterested when the lawyer knows, reasonably should know, that the unrepresented person misstands the lawyer's role in the matter. The lawyer shall make reasonable efforts to correct a misunderstanding. In other words, the lawyer says should tell you that he can't talk to you. You can't talk to them unless you have legal counsel representing you. Okay? Nobody's supposed to talk to you without legal counsel representing you, thus the interrogation, right to remain silent, okay? Your rights will always be infringed upon unless you know what they are and use them. Okay, responsibilities of partners, managers, and supervisory lawyers. Let's say this assistant state's attorney violates the rules of professional conduct. You can hold their supervisor responsibilities of a subordinate lawyer. It says a lawyer is bound by the rules of professional conduct, notwithstanding the lawyer acted at the direction of another person. A subordinate lawyer does not violate the rules of professional conduct. The lawyer acts in accordance with supervisor lawyer's reasonable resolution of argued question of professional. So only if it's reasonable. Okay. So you can still hold them accountable if it's a reasonable resolution. Responsibility regarding non-lawyer assistance, restrictions of the right to practice. They have no right to practice when they violate any of these. Anytime they violate one, they violate them all. Okay. Dealing with enough responsibilities, professional independence, unauthorized practice, accepting appointments. Okay, there's a lot of stuff you're gonna want to use. Reporting professional misconduct. Nobody does this. That's why we're all in a shit barrel. Okay, and swimming in it. Reporting professional misconduct. A lawyer who knows that another lawyer has committed a violation of Rule 8.4, which is misconduct, or Rule 8.4C, shall inform appropriate professional authorities. That means to the court they're standing in front of, and then to the Judicial Inquiry Board if it's a judge, or the ARDC in Illinois, which is the Attorney Registration Disciplinary Commission, which causes for immediate removal of their license to practice, yada, yada, yada. A lawyer who knows that a judge has committed a violation of applicable rules of judicial conduct arises a substantial question of the judge's fitness for office shall inform the appropriate authority. See, so the lawyers are supposed to tell on the judge for not telling on them. Okay? So since misconduct, reporting professional misconduct, I showed you, is in the Code of Judicial Conduct. It mentioned Rule 8.4, which is misconduct. So if judge knows of misconduct, the judge should report professional misconduct, cite all the violations, which are as follows: lack of competence, a lack of diligence, a lack of communication, a lack of confidentiality of information. I'm just going to go over this real quick. Declining, terminating representation. A lot of lawyers will do that if you bring up the rules of professional conduct. Rule barrier stories, claims and contentions. Expediting litigation. Fairness to the opposing party and counsel. Impartiality and decorum of the tribunal. Trial publicity. You know, a lawyer always seeks trial publicity. We'll go over that in a minute. Okay, special responsibilities of the prosecutor, truthful statements to others, dealing with unrepresented persons. Okay, see, so reporting professional misconduct. Oh, that was a whole lot of misconduct there, right? And reporting is mandatory through the rules of professional conduct and the Code of Judicial Conduct, all right? So if you want to take them all down, remember, it's over here. A judge having knowledge of the violation of canons or violation of 8.4, the rules of professional conduct, order shall initiate appropriate disciplinary measures. So simply because the judge didn't report misconduct, okay, because reporting professional misconduct is mandatory, you know, you can go up there and demand the judge recuse himself for failure to report misconduct, and reporting misconduct is misconduct in itself. The judge is supposed to report the lawyers for misconduct and himself for the failure to report misconduct. I mean, I could go on and on, okay? So I want to, I was trying to come up with something that I could use in every state, but the preambles are different in every state. So I need you to study the rules. And you could just use the word, just as I did, okay? Right here, lack of competence, failure to comply. You've been denied your right to due process. Okay, this is due process. Okay. Now, like I said, you can download all the rules, which I did. Code of Judicial Conduct, rules of professional conduct. All right, that's all you need. You take both copies of both. Take a copy of the definition of rule of law, letter of the law, and spirit of the law. Because they're going to act like big old dummies and tell you, hey, well, see, that's not how we do this. This isn't how we interpret this. You don't need anybody to give you any interpretation, what they feel or think how it should work. Okay, just go over this, people. Okay, I found. Listen, you actually have to be a lawyer. Well, before the age of the internet, you had to be a lawyer to learn this. And I haven't been to law school, no, but I tried, but I couldn't afford it. Well, just because they kept me out of the school didn't mean they could keep me out of the books. All right, now I'm giving you a synopsis of what I've picked up throughout the years and that are in books. And now these books, these law books are on the internet. Use it. Okay? Okay, so remember, take a judge out. You're going to use the canons. All right? And just this part alone, a judge having that violation of these canons on the part of a judge or a violation of Rule 8.4, the Rule of Professional Conduct on the part of the lawyer shall take and initiate appropriate disciplinary measures. And because they don't, you've been denied due process. Okay? The judges knowingly and willingly do this to you. They do it to everybody. All right? So, you file with the Judicial Inquiry Board. At the very least, you get a do-over. Let's go over the preamble of the Rules of Professional Conduct, all right? See, it says right here, preamble, a lawyer's responsibilities. It used to say legal responsibilities. I don't know why they took that out, but they're doing more. Really, they got to put it back the way it used to be. 1979, the revised edition, it was beautiful compared to this. A little more lengthy, but they seem to have forgotten that the Constitution, due process, was meant to protect us from them, not them from us. So if you understand that, rule of law, look it up. Rule of law, it's a simple definition. It's a law. Okay, and nobody does that. They put themselves above the law, and you below it. They literally deny your right to due process in every sense of the word, but you'll have to read the Rules of Professional Conduct and the Code of Judicial Conduct, and you're going to use the Code of Judicial Conduct to take out the lawyers and the judge. You'll let the judge will basically is taking out themselves for not reporting misconduct, and like you'll want to go over the other canons as well. Lawyer is a member of the legal profession, is a representative of clients and an officer of the legal system, and a public citizen having special responsibility for the quality of justice. That's a representative of clients. Lawyers perform various functions as advisor. Lawyers provide client with an informed understanding of the client's legal rights. They don't do that. They don't communicate with you. And obligations, explaining their practical implications as an advocate, the lawyer zealously asserts the client's position. They don't do that under the rules of the advisory system, meaning the rules of professional conduct and the Code of Judicial Conduct. As a negotiator, lawyers shall seek results advantageous to the client, but consistent with requirements of honest dealings with others, meaning they can't bullshit the other side. It has to be total honesty. As a valid lawyer acts by examining a client's legal affairs by reporting about them to the client or to others. In addition to these representational functions, the lawyers may serve as a third party, neutral. We're not worried about that. In addition, these rules that apply to lawyers who are not active in the practice of law, practicing law, even when they are acting in a non-professional capacity. For example, a lawyer commits fraud in the conduct of a business is subject to discipline for engaging in conduct involving dishonesty, fraud, misrepresentation. See Rule 8.4. Misconduct. That's misconduct. In all professional functions, a lawyer should be competent, rarely happens, prompt, and diligent. We just went over the rules. You know they don't do. There is nothing prompt and diligent about them. Why so many continuances? It's what they like to call billable items. A lawyer shall maintain communication with the client. That doesn't happen. Concerning the representation, the lawyer should keep in confidence information relating to the representation of a client except so far as disclosures required or permitted by the rules of professional conduct. Like when I told that, look, my lawyer, I said, yeah, he said, what do you think you're going to tell the judge, that the judge is going to, I says, I'm going to tell the judge to do her job. Report misconduct. Reporting misconduct is mandatory in the rules of professional conduct as well as the code of judicial conduct. He took off before I could say that's ineffective assistance of counsel. Everybody in the courtroom is ineffective, So if I could have managed to get on the record, I would have told the judge, you have to recuse yourself for the simple fact you violating the code of judicial conduct, not reporting the rules of professional conduct, leaves you in contempt of the very court you preside over. Recuse yourself. And don't forget to report yourself to the Judicial Inquiry Board and all these guys, to the Attorney Registration Disciplinary Commission. And don't forget, guys, hey, what's my name? Don't forgive it to your legal malpractice insurer, because legal malpractice is mandatory for everybody that has a legal license, a law to practice law. Lawyers don't like hearing me talk, I'm telling you. You have to excuse me all those other times people said I sound like, I was not trying to sound like a lawyer. I was just reading this to you. Lawyers' conduct should conform to the requirements of law, both in professional service to clients and the lawyer's business and personal affairs. Remember that, people. And remember, lawyers are supposed to be apolitical. Lawyers should use their law procedure only for a legitimate purpose and not harass or intimidate others. That's when I was telling you about a probable cause hearing. For your lawyer not to throw out a probable cause hearing first, quick, fast, and hurry, the first thing, that's for the purposes to harass and intimidate you. How if they don't do that, how are they going to get continuances and have billable items? And you wind up an indentured servant, destined to be an indentured. You're never going to be able to pay off this guy, and you're going to work the rest of your life. No, demonstrate legal respect for the legal system and those who serve it, including judges, other lawyers, and public officials. While it's a lawyer's duty, when necessary, to challenge the rectitude of official actions, a lawyer's duty to uphold the legal process, abiding by the code of judicial conduct, rule of professional conduct, is the legal process. As a public citizen, the lawyer should seek improvement in the law, access to the legal system, administration of justice, quality of service rendered to the legal profession as a member of the learned profession. Remember, you are not a member of the learned profession. You didn't have the money. You didn't go to law school, so quit trying to act like a lawyer and do all that other stuff I've been telling you guys not to do. Just do this, all right? All that other stuff you've been doing, that's the weight of evidence you're going to use, when you claim, mental anguish, pain and suffering, that's what you're going to use afterwards. See, before you can tell your story, all you got to do is cite this. You don't even have to tell your story, and they're cooked, all right? A lawyer should cultivate knowledge of the law beyond its use for clients, employ that knowledge of reform of the law, and work to straighten legal education. In addition, a lawyer should further the public's understanding of the confidence in the rule of law and the justice system, because legal institutions in a constitutional democracy depend on the popular participation and support to maintain their authority. It is also the responsibility of those licensed officers of the court to use their training, experience, and skills to provide public service in the public interest, for which compensation may not be available. It is the responsibility of those who manage law firms to create an environment hospitable to rendering a reasonable amount of uncompensated services by law. Service in the public interest may take forms that include not limited to pro bono. The absence from the Illinois Rules of Counterpart, American Model 1.6 or 6.1 regarding pro bono, I don't even want to deal with that. Many of lawyers' professional responsibilities are prescribed described in the rules of professional conduct as well as substantial procedural law. A lawyer is also guided by personal conscience and approbation of professional peers. Lawyers should strive to obtain the highest level of skill to improve the law, legal profession, and exemplify legal profession and public service. The lawyer's responsibilities represent to clients, officer of the legal system, public citizen are usually harmonious. Thus, when opposing party is well represented, a lawyer can be zealous advocate on behalf of the client, at the same time assume that justice is being done. So also a lawyer can be sure that preserving client confidence ordinarily serves the public interest, okay? Now be wary. So also a lawyer can be sure that preserving client confidence ordinarily serves the public interest because people are more likely to seek legal service and thereby heed their legal obligations when they know their communications will be private. Like I said, my lawyer ran and told the judge that wasn't a private conversation. He went and warned the judge, and the judge had the sheriffs take me to the woodshed and beat the life out of me. I'm surprised I'm alive to tell my story. And I'm pretty sure they're going to rain a whole lot of hell in my life once they figure out who's doing this. But I'm not worried about me. I'm worried about you. All right? I don't want to happen to me happen to you. So, the easiest way to make it not happen is the way I tried to make it not happen. By using their words against them, by using the oath they took. The oath they took is to uphold, defend the Constitution. So far, all they're doing is defending the Constitution against you. They're withholding your right to due process. Can you understand that? That's treachery. That's sedition. That's treason. Remember, rule of law is established in the Constitution. The need of the many outweigh the need of the few, and this is how the few get rich and make you their bitch. Okay, so lawyers get mad at me when I refer to the rules of professional conduct as to own your bitch book. How to own and operate your attorney. I've had, but I'm not going to stop. They can't stop me till they drop me, and I'm quite sure they did it once. I'm quite sure they're going to do it again. But I ain't worried. What I'm worried about is you, all of you. I'm your biggest fan. When it comes to we the people, I am your biggest fan. I read that the first time in the 5th grade, and knowing that it didn't stand for all, put me on a quest. Okay, such issues must be resolved through the exercise of sensitive, professional, and moral judgment guided by the basic principles underlying the rules. These principles include lawyers' obligation zealously to protect and pursue a client's legitimate interest within the bounds of law while maintaining a professional, courteous, and civil attitude towards all persons involved in the legal system. Legal profession is largely self-governing, although other professions have been granted power of self-government. The legal profession is unique in the respect because of the closer relationship between the profession and the process of government of law enforcement. This connection is manifested in the fact that ultimate authority over the legal profession is vested. Okay, largely in the courts. To the extent a lawyer meet the obligations of the professional qualification for government regulation is obeyed. Self-regulation also helps maintain the legal profession independent from government domination. Independent legal profession is an important force in preserving government under law. For abuse of legal authority is more rarely challenged by professions. Members are not dependent on government for the right to practice. Legal profession relative autonomy carries with it special responsibilities of self-government. The profession has the responsibility to assume that its regulations are conceived in the public interest. Okay, the profession has a responsibility to ensure that its regulations are conceived in the public interest and not furtherance of patriarchal self-interest concerns of the bar. Meaning, they got to do what's best for you and not them. Okay, the needs of the many outweigh the needs of the few. Okay. Every lawyer is responsible for the observance of the rules of professional conduct. Lawyers should also aid in securing their observance by other lawyers. So if one lawyer knows another lawyer is breaking the law, violating the rules of professional conduct, I mean, if they were a cop, they would be legally obligated to take out a pistol and shoot him in the head. That's sedition, that's treason, that's treachery. Neglect of these responsibility compromises the independence of law, profession, public interest, which it serves. Okay? The independence of the public, of the profession, and the public interest, which it serves. Okay? I didn't write this shit. They did, okay? So get with me, people, all right? Learn this shit. Lawyer plays a vital role in preservation of society. The fulfillment role requires an understanding by lawyers that their relationship to our legal system, the rules of professional conduct, when wrongfully applied, serve to define that relationship. Okay, the scope you want to go over. Remember, apply letter of law means there ain't nothing nobody can tell you outside of what it says right here. It is what it is. It says what it is. It says what it says. Let's make this happen, people, okay? The rules of professional conduct are rules of reason should be interpreted with reference and purpose and legal representation of the law itself. Some of the rules are imperatives. Cast of team shall not. Okay. So you just okay, over here, violation of rules should not itself give rise to cause. Violation of a rule. I just went over it with you. Every time a lawyer appears in court, there's a multitude of violations. Okay, you can cite them for multiple counts of misconduct and then cite the rules. Any violation of one rule is misconduct. So you can cite them for every rule, and for every rule they violate is misconduct. The rules are designed to provide guidance to the lawyers and provide a statute of regulating conduct through disciplinary issues. Okay. But you're going to want to go over the preamble. Okay, scope terminology. Preamble scope. Okay, sorry about that. Okay, well, that's for the most part, all right? This is what you just need to get in your head. I'm going to come back to you. But remember, a failure at competence, you must be diligent, competent, you must communicate. There's a lot of things lawyers are supposed to do they don't do, Fairness to the opposing party and counsel. That would be expediting litigation. There's no reason for constant continuance. There's no reason for a continuance for anything. Partiality, decorum of the tribunal, which means the judge. Trial publicity. Lawyers participating in investigation litigation shall not make or extrajudicial statement the lawyer knows unreasonably should know will anticipate means of public communication. Which usually means trial publicity, when they talk about somebody's on trial. And they'll talk about their past criminal history. And they'll say, he's been arrested 28, 30 times. How many convictions? 2. One for marijuana, another one for traffic, what have you. But he still got those 25, 26 arrests. Now, all those arrests were just arrests. When they went to court, they were thrown out. They were thrown out on no probable cause. So no probable cause for arrest is what they actually are. If they're thrown out, it's because of no probable cause for arrest. So why are they using 25, 27 no probable cause for arrest against you? They just call it an arrest. You've been arrested so many times. But they don't mention that those cases were dismissed because of no probable cause for arrest. which comes down to legal harassment. Okay, so see, if I go read all this for you, going back and forth, it's going to take hours on end, which I wouldn't mind, but most people lack the attention span. I've had people sit here with me and went through them and literally fell asleep. I couldn't understand that. They wanted resolution to their cases, but and I told them it'd be easier if you read it to yourself. And I printed out copies and gave it to them and highlighted every issue I thought they should bring up. And they don't do it. They don't do it. So the easiest way to get a judge to remove from the bench is go over all of this. I mean, they have a rule for probate. So if you've been through probate court, well, hey, they didn't go over all this with you, right? I had some people tell me, well, I did okay. You know, it wasn't that bad, but see, you could do a lot better. Just get the name of the judge, throw the judge's name. That's me, not me. Okay. We'll get the judge's name, and I showed you the form right here, the complaint form. Use federal court. Okay, where? Well, let's use for the U.S. federal crimes. See? So talk to your computer, like I do. And man, this has been in my head for so many years. When I was younger, I used to dream, man, one of these days, I can tell the people, my people, we the people, all about how they're getting screwed over. Now I can tell the world. My old ass had to buy a computer and figure out how to use it. My day, computer was an abacus. You know, in high school, the only computers we had were calculators. They were big, huge. The first one was as big as a car. Okay, so remember, people, you want to take a judge out, let's go here again. Okay. Code, Illinois. We'll go here. So since I'm in Illinois, it says, yes, you must report judicial misconduct. Illinois State Bar. Okay. It's on the net, people. This is actually law books and shit, you know, on the net. How to submit a request for investigation, ARDC, that's the Attorney Registration Disciplinary Commission. When I filed with the ARDC, and I stated everything that we just discussed, they told me get a lawyer. No lawyer is going to do this. It's like getting a cop to arrest a cop. It ain't going to happen. Okay. Did it again. Illinois courts, opinions, rules, law, forms. Well, remember, violating the oath of office. All right. You want to look that up. How do I file a complaint again? Request a complaint form by contacting. Okay. You may also download a complaint form at the board's website. Let's try this again. Well, this is legal reform. The only legal reform you need is to learn what due process is. That's the Code of Judicial Conduct, the rules of professional conduct. The Code of Judicial Conduct, we went over the rules of professional. I'm going to go over the Code of Judicial Conduct with you again, just by itself, and then the rules of professional conduct just by itself. But I just gave you a synopsis, which is like so far an hour and 17 minutes. So the other ones are going to take longer, okay? Facebook keeps telling me to hire people. I don't have any money. I'm broke. I keep myself broke helping people. I went to courts. You know, before this, I actually went to the local courts, Cook County Court. I've been to other states. Last state I visited and obtained this information was in Boise, Idaho. You know, I just had to know. I had to know, is this only happening to me? So I started going to other, courts, helping other, finding out what other is. So it turns out it's happening in every court I went to: child court, custody court, divorce court, criminal court, civil court. Nobody plays by the rules. Nobody abides by the codes. Nobody reports misconduct. Reporting misconduct is mandatory in the Code of Judicial Conduct and the rules of professional conduct. And you get to know those, use them. That's how you get resolution. The only legal reform you need is to go in that court and make sure nobody pulls any shenanigans and pull out the codes of judicial conduct, highlight every issue you want to discuss, go over it with the judge. The judge has to listen to you. Okay? So it's the lawyers are, and make sure you demand they use layman terms, okay, so you can understand what's going on. They think they're, dazzling you with brilliance, but they're baffling you with bullshit, all right? No more bullshit, that's all. Tell them to stop it, all right? I mean, I've seen people, somebody told my dad that. He was speaking Spanish to me. I don't even understand Spanish that good. Somebody told him English only, and I had to get into his face. You know, so you're gonna demand English only. Demand it in the court of law. Well, layman's terms, anyway. You can't demand it. That's your right, right? Remember, in fairness to the opposing party, you know, keep it in layman's terms. Okay, that's about as hard as it gets, people. Thank you and good night. Remember, if you want to talk to me, you can call me Pops. It's kind of my name, but it's also what I do. Protecting our peoples. All of them. All of them. United we stand. Divided, we will not only fall, but we will fail. We all want the same thing. Rule of law. Nobody above the law, nobody below it. Apply letter of the law. It is what it is. It says what it says. It has been written, so let it be done. Make it so. You know, spirit of the law. We the people. Simple as that. What is done has to be done for the greater good. For the greater good. All right? And people really, we need leaders not in love with money, but in love with justice. I love justice, and I want you to get it, and this is how you're going to get it. And the only reason it took me so long, because I'm not in love with publicity. I was literally spending money trying to get people to explain this to you. I'm a behind-the-scenes guy. I'm a recluse. I enjoy my privacy. I find solitude and seclusion. All right? I can hear myself think. And it's, you know, I enjoyed doing this for years. I've enjoyed going to courts and ripping lawyers and judges a new one. And to me, this is exciting. But now I have the internet. I have World Wide Web, access to the internet. And plus, I can't get in 5 minutes into a conversation where somebody wants an explanation why they don't do this, why they don't do that. Well, see, that's not for me to answer. That's for your lawyer and judges to answer. Why? Ask them, why are they violating the law? I mean, not doing this is violating rule of the law, letter of the law, spirit of the law, your right to due process, all right? That's all I'm going over with you. Your right to due process. You have no rights unless you flex them, just like your right to remain silent. You know, you have the right to remain silent. Anything you say can and will be used against you. You have a right to an attorney. Remember, that right to attorney includes a right to effective assistance counsel. Any lawyer that violates the code or the rules of professional conduct is ineffective. Ineffective, defective, and destructive. All right, keep that in mind. All right, there's a lot of things where I'm going to want to talk over with you. And maybe it's a good thing I don't have anybody sitting here with me because I never get to say anything or get it done. All right, good night. Good night, people. Love you. Remember, when it comes to we people, Pops is your biggest fan and your devoted servant.